guys, welcome back to another episode of Lawyered Up. I am your host, Jared Moore, and for the record, I am not a lawyer. Lawyered Up is a program where we go through court documents and recent filings and things like that to try to explain them as best we can, understand them as just regular Joes. So some of the stuff I'm going to go through today, I'm just going to touch on it because I talked about it, some of these topics during the election live stream, but I know some of you guys weren't able to catch the election live stream. And rather than go back and say, hey, go watch it over there, I figured we'll just do it real quick and lawyered up because it is lawyered up stuff. And then the main topic that we're going to be talking about today is the Supreme Court's most recent order in the Freedmen case. So to start off with, you may have seen in the local news or anything, a motion in Mvskoke Creek Nation versus Steve KUNZWEILER that was denied. And I just wanted to run through that really quick and explain it. It happened a while back, but I don't think we ever covered on Lawyer Up. So let me pop this up for you first and we'll jump in with that. So what we're looking at here is in the United States District Court for the Northern District of Oklahoma, Mvskoke Creek Nation versus Steve KUNZWEILER. This is a lawsuit that was filed and a motion that was filed by the Creek Nation to get an injunction against Tulsa County District Attorney Steve KUNZWEILER from asserting concurrent criminal jurisdiction over Indians who are not members of the nation and who allege to have committed crimes not covered by Major Crimes Act within the boundaries of the nation's reservation. So I'm just going to go through here and read this really quickly. What we're basically talking about is jurisdiction preemption. So the nation is arguing basically that since this is on the Creek Nation reservation and the individuals in question are Native American, they're citizens of a tribal nation, they're not Creek Nation citizen, the Creek Nation should have jurisdiction over them. And let me skip down here. In a nutshell, I'm going to read the section in here, but what the judge said is that there are certain factors that can allow that preemption of state jurisdiction to happen. And one of them is if it adversely affects tribal sovereignty, which the judge said that because these tribal citizens aren't Creek Nation citizens, that doesn't happen, and so he denied the injunction. But let me go down and I'll read that section for you. Let's see here. I think it's on page 4 that it starts. Here we go. Although, and I'm reading here, you guys can see, although the holding in Castro Huerta does not address the issue raised in this case, the opinion sets forth the preemption analysis by which issues of a state's criminal jurisdiction in Indian country must be evaluated and decided. After reviewing its precedents, the court stated, in short, the court's precedents establish that Indian country is part of a state's territory and that, unless preempted, states have jurisdiction over crimes committed in Indian country. State jurisdiction may be preempted, 1, by federal law under ordinary principles of federal preemption, or 2, when the exercise of state jurisdiction would unlawfully infringe on tribal self-government. So there you go. Those are the two ways that in the Northern District's opinion, that state jurisdiction could be preempted. And what the judge is saying is basically, since these tribal citizens aren't Creek citizens, then the state jurisdiction isn't preempted. And so that's in a nutshell. There's been a lot of coverage on that, but I wanted to touch on that denial just to let you guys know. What's next on the list? Another thing we talked about during the election live stream that I don't think we've covered at all on Lawyered Up is the ongoings down at Thlopthlocco Tribal Town. So, and by the way, guys, there's links to all of this stuff that I'm talking about in the description of this video if you want to go and read it on your own time for your own perusal. So let's take a look at that. First off, so what are we looking at? This is in the District Court for Mvskoke County, Oklahoma, Thlopthlocco Tribal Town versus Smith, Brent, and a whole bunch of other people. You can see all the people listed here. And I'm going to scroll down. And you can see all the things now they're having an argument about whether the court has jurisdiction. But I'm going to read the original filing so that you guys can get an idea of what's going on. And, before I jump into this, hold on just a second. We do have a coverage of this up on our website. There's a link in the description. This story here, attempted break-in at Golden Pony shuts down operations, MCN Light Horse and BIA investigates. So this is ongoing. This is tied into this story, but I'm going to start with the legal filing because the legal filing happened before this attempted break-in. So what we have here is Thlopthlocco Tribal Town, federally recognized Indian tribe. Plaintiff is filing against Brent Smith, and then another group that's led by Nathan Anderson. And the Thlopthlocco Tribal Town is, hold on a second, let me scroll down here. Thlopthlocco Tribal Town is being, well, I want to get to the, just a second, guys. There's so many pages. Let me do this. Is this one? Brent Brown is who's on there. Now, I want to let you guys know that Brent Brown, if you go to our coverage here, you'll see that we have a hyperlink to, this is our coverage, and you can see there's a hyperlink here to the BIA's tribal leadership directory. And if you look up Thlopthlocco Tribal Town, you'll see here on the side over here, I don't know if you guys can see that, that the BIA is recognizing Brent Brown. Oh, they've changed it. They've actually changed this since the last time that we covered this. Now it's saying, the BIA is saying Town King subject to tribal leadership dispute, Brent Brown, Nathan Anderson, and Brent Smith. So it looks like the BIA is saying that they don't really know out of those three guys who is in charge. But for the purposes of what we're going to read through here, this filing I'm going to read is, hold on, let me pop back up so I can explain what's going on. So I'm going to read the original filing in this case that's in the Mvskoke District Court that was filed by Brent Brown, saying he's the Miko of Thlopthlocco Tribal Town. At the time this was filed, if you went on the BIA's tribal directory to see who was the head of the tribal town, the BIA had on there Brent Brown, but now it looks like they've changed that. Regardless, I'm going to read what Brent Brown says has happened to cause this filing. And then just to give you an idea of some of the events that are going on there. Let me scroll up here. Here we go. Just a moment. I'm trying to find the part where they go over. Here we go. Okay. So, Thlopthlocco Tribal Town, a federally recognized Indian tribe, is tribal land located within Mvskoke County, and so on and so forth. And explains how their government works a little bit. And it says that after the conclusion of certain tribal litigation in the courts of the Mvskoke Nation with further proceedings in the United States District Court for Northern District Oklahoma and the United States Court of Appeals for the 10th Circuit, Thlopthlocco is in the process of preparing for tribal elections. You guys may remember we covered that and lawyered up, and basically the conclusion of it was that we probably won't, the reason this is getting filed in Mvskoke District Court is because Thlopthlocco doesn't want to come back into Creek Nation courts because of those mentioned things that happened, right? Let's go back into here. Let me scroll down here. Thlopthlocco previously relied upon judicial services from the Mvskoke Creek Nation. The MCN Courts has since refused to recognize certain aspects of Thlopthlocco's sovereignty. Moreover, the MCN judiciary took 6 years to resolve an issue of Thlopthlocco sovereignty, even though they were directed to do so by the United States Courts of Appeals for the 10th Circuit. Even after that directive, MCN courts sidestepped the issue, leaving it unresolved. Under these circumstances, it is not reasonable for Thlopthlocco to rely upon proper adjudication of any election disputes or any other matter involving Thlopthlocco governance in tribal courts of the MCN. So that's basically what I was talking about. They're saying this is why we're bringing this to the Mvskoke District Courts, because we can't go back to Creek Nation anymore. And that's Brent Brown's opinion. Let's see here. Okay. So this is what they say, Brent Brown's saying happened. At a recent quarterly membership meeting on October 18th, certain members of Group 1 rose at the conclusion of the meeting and made a motion that the business committee resign. The meeting was adjourned, and the official part of the meeting ended. Nevertheless, members of Group 1 defendants remained on the property, conducted an unauthorized election, and declared they were the new business committee. They refused to vacate tribal premises. Any such election was invalid, and so on and so forth. I'm going to scroll down here. Tribal security officers remained monitoring the members of Group 1 and other tribal members aligned with them. Tribal security officers are not commissioned officers, although they have CLEAT training. Tribal security officers called the Mvskoke Creek Nation Light Horse Law Enforcement. The Light Horse arrived and made the members of Group 1 leave the premises, but at the same time barred both Group 1 and the current members of the Thlopthlocco Business Committee from occupying the South Community Center and also the offices of the tribal Miko and treasurer located across I-40 in the White House on tribal property. Light Horse officers said they would consult with the MCN Attorney General on Monday to determine how to proceed. On Thursday, October 23rd, Defendant Brent Smith and other members of Group 1 arrived at the Thlopthlocco Social Services Office and began confronting Thlopthlocco officials and employees, claiming they were the new business committee and threatened to have the officials and employees fired if the officials and employees did not acknowledge that they were the new business committee, and otherwise harassing them in performance of their duties. Defendant Brent Smith and other members of Group 1 were told to leave by tribal officials but refused to do so. To protect the employees from continuing harassment from Smith and his group, the Miko authorized employees to leave the premises. Smith and his group remained. Under the direction of the Miko, tribal officials contacted MCN Light Horse to let them know that certain members of Group 1 had returned to the tribal premises and were disrupting the work of tribal employees and refused to leave when told to do so. MCN Light Horse never appeared and sent a message they did not intend to return in to assist in law enforcement. Okay, so I'm going to take a break right there. So you guys see what's happened so far according to Brent Brown. Now in our coverage, where did that go with this? Sorry, there we go. In our coverage here, there were some, we got in touch with the AG about this issue, and the AG kind of explained, and you can read the story. I encourage you to read it, that the MCN is trying to not get involved in their political process. So that's why they're only going to respond to calls down there that where crimes are being committed. They're not going to intervene in political disputes, basically, is what she was saying. They're still going to enforce a rule of law, but they're not going to get involved in the Thlopthlocco political machinations, is why some of these things they showed up to and some they didn't. So going back to that filing, let's see here. I'm going to scroll on down to see the other side of this. Because there's another issue, Group 2 defendants. So there's two groups. One of them is being led by Brent Smith, and one of them being led by Nathan Anderson. You guys may remember Nathan Anderson from some coverage last year where he tried to call an election in the newspaper, and we had to run a retraction because we got contacted by the leadership of Thlopthlocco saying that he's not doesn't have anything to do with the government, so on and so forth. So let's see what Brent Brown says that Nathan Anderson did. So it says, Defendant Nathan Anderson, members of Group 2, also have no official authority as Thlopthlocco tribal officials. Defendant Anderson was elected Miko Thlopthlocco in 2007. His election, and then he's going to go back through the long, this is a long court case that resulted in the aforementioned 10th Circuit decision. Yeah, here, let's start here. This is a good place. Defendant Anderson attempted to call another election for February 22nd, 2025. This was not authorized by the Business Committee nor conducted by the Election Committee in accordance with the election ordinance. The notice for election consisted of a single display ad in the Okemah newspaper, which stated the election was to take place on January 22nd, 2025, the wrong date. Defendant Anderson arranged the meeting at local church family center. Anderson had no current membership list from the enrollment committee to ensure only tribal members voted. The Thlopthlocco Constitution states that eligible voters are 21 years or older, but an announcement was made at the meeting the voting age was 18 years or older. After the election, in a letter dated February 24, 2024, Defendant Anderson notified numerous federal officials in the BIA of the election results. Again, the present business committee continues to be recognized on the website. Now that's been changed. Defendant Anderson later sent a demand dated June 12, 2025 to the business committee that they transition the government to his group. And he had a letter from the BIA superintendent. The letter denied a request for an election conducted by the BIA and stated that the agency would not become involved in internal tribal matters. It did not support any claim that Anderson's group was properly elected. So I'm going to skip down here. You can see that Anderson's trying to say that he's the chief. And then this part, Defendant Anderson made a request and later submitted a threatening letter from his attorney to the bank used by Thlopthlocco as a repository for tribal funds. This necessitated a meeting on July 30th with bank officials by the business committee to determine whether tribal government had changed. And then they go on and on. So then they ask for the injunctions. So while all of this is going on, after this was filed, this particular complaint, Brent Brown says Thlopthlocco is going to waive sovereign immunity to appear in the Mvskoke District Court. Okay, and then the two other groups filed stuff in the same case. You can see it here. Let's see here. So we have the petition right there that I just read. You see all these summons that were issued and so on and so forth. And then you see these filings, emergency stay for temporary restraining order pending resolution of special appearance and motion to dismiss for lack of subject matter jurisdiction. That's Nathan Anderson and Brent Smith saying, we're in charge of Thlopthlocco and we don't consent to the jurisdiction of Mvskoke Court. And then if we keep scrolling down here, you can see that this has been put on a Supreme Court emergency application petition has been put in both of these cases where they are petitioning the let's take a look at it really quick to make sure. They are petitioning the Supreme Court of Oklahoma, yes, to get involved and say, hey, we're in charge of the Thlopthlocco tribal town. So there's a whole bunch of stuff going on in this tribal dispute of the leadership. While all of that was happening, there was an attempted break-in at Golden Pony that shut Golden Pony down, and so the feds and the Creek Nation are down there investigating that. I don't know if the casino has opened back up yet because, like I said, this was published on November 8th, but I don't think that it has. I've driven by there, and I don't think the lights are on or anything that the casino's operating. It might be back up, but I don't think so. So, like I said, you guys can read any of the documents in that docket, and you can read our coverage of it, and we'll have some more updates when we find something out. But I'm going to move on to the next thing. Let me close some of these tabs here. The next thing that you may have seen, and I've got this is a good non-doc story. Again, there's a link to it in the description of this video. It goes through the whole saga. Basically, Governor Stitt wanted the, let me get the organization correct here. Where is it? Governor Stitt wanted the Oklahoma Department of Wildlife Conservation to start prosecuting tribal citizens who were hunting and fishing on reservation land. Okay? Without an Oklahoma hunting license. I believe that Gettner Drummond's the Oklahoma AG said he's not going to prosecute those, I think is what happened. So then Governor Stitt got a special prosecutor to do it named Russell Cochran. Okay. Now we have the Choctaw, Chickasaw, and Cherokee nations have filed a suit against the Oklahoma Department of Wildlife Conservation, Governor Stitt, and the special prosecutor to get this settled in court, whether they can prosecute these tribal citizens on the reservation. And like I said, this story is really in depth and it has everything. So go and check that out. It's not, Creek Nation is involved in this yet, but I imagine that at some point the Creek Nation will probably get involved because there's similar issues. Okay. What's the next thing? Oh, okay. We're at the meat and potatoes. We're at the meat and potatoes, you guys. We can close everything. Okay. So we are, as usual, on the Creek Nation Supreme Court's website. We are going to go to final opinions. We are going to go down to SC 2023-10. I'm going to get you guys caught up, and then we will take a look at what the Supreme Court has ordered in this case most recently. So, you guys may remember that the Supreme Court issued its order and opinion on July 23rd, saying that Grayson and Kennedy needed to be given Creek Nation citizenship. After that happened, there was a petition for rehearing that got denied, right? Then there was a motion for contempt filed by Grayson and Kennedy on August 27th, basically saying, hey, Grayson and Kennedy want to vote in the election, and the Creek Nation Citizenship Board is slow walking this. They haven't given them their citizenship, and they're not going to be able to vote. And the Supreme Court denied that motion for contempt, saying, well, there hasn't been enough time for the necessary changes to be made for them to get their citizenship. And part of our ruling didn't say that they had to get their citizenship in enough time to vote. So they denied that. Okay. At the same time that motion for contempt was filed, or I think it was the day after, Chief Hill issued an executive order saying that all the departments of the nation and the executive branch need to get any changes that need to be made to any amendment to the Constitution, to code, or anything, or to the Citizenship Board's policy and procedures. We need to get those. They need to be brought up to the Chief's office and the Citizenship Board so that we can start the legislative process to get this done to comply with Supreme Court's order. Okay? So that executive order was issued. Then after that, on, let's see here, October 14th, Grayson and Kennedy renewed their motion for contempt, saying, hey, nothing's been done. It's October now, and Grayson and Kennedy still don't have their citizenship. They also challenged aspects of Chief Hill's executive order, saying basically, Chief Hill during the case and in other cases has said that the principal chief's office doesn't have any control over the Citizenship Board. And now he's issuing an executive order, giving orders to the Citizenship Board not to give people citizenship. So which one is it? Then, while we were waiting on the Supreme Court to issue a ruling on that renewed motion for contempt, there was a response from the Citizenship Board that basically kind of like outlined what needed to, in the opinion of the Citizenship Board, needed to happen before they could grant the citizenship. They have to publish any changes in the Mvskoke Nation News. They have to give those changes to the Creek Nation National Council Secretary and the court clerk and so on and so forth. There's all this bureaucratic stuff that they need to do. And they also pointed out in there, well, let's take a look at it. I don't think we've gone over the response to that motion, that renewed motion. So let's take a look at it, right? So this is where we are. Appellant Citizenship Board's response to renewed motion for contempt. Got to zoom in here. Where are we at? 424. We are doing good. So this is a recap. Okay, this is what we're talking about. I'm going to start from here. On August 28, 2025, Principal Chief David Hill issued Executive Order number 25-05, which directed the Citizenship Office to continue accepting applications, but not to issue citizenship or any other form of membership identification cards to Freedmen descendant applicants until, quote, all law and policy have been fully reviewed and amended to meet the qualification requirements under Article 2 of the Treaty of 1866, end quote. Principal Chief further ordered all department heads to review policies and procedures to propose necessary amendments to be consistent with this court's order. Necessary changes that require National Council approval would be submitted by the Principal Chief for review and approval. As the court previously found, the Citizenship Board, although a constitutionally formed entity, is part of the executive branch, and then it quotes previous ruling. Since the Executive Order 25-05 was entered, the Office of the Principal Chief and Attorney General's Office have prepared proposed code amendments to be circulated to the Citizenship Board for review and comment. Independently of that work, the Citizenship Office has reviewed its internal rules and regulations and formulated proposed amendments. However, amendments to the Citizenship Board's policies and procedures cannot be enacted till the National Council acts on the proposed amendments to Title VII to ensure that said policies and procedures comply with the code amendments. Further, any change to the Citizenship Board's rules and regulations are subject to the Board's rulemaking authority as set forth in Title VII, which states, rulemaking authority of the Citizenship Board shall have the authority to prescribe, promulgate, and enforce without National Council approval such written rules and regulations as may be necessary to administer and enforce this title, including without limitation rules and regulations for internal operating procedures for review of citizenship applications, for hearings and appeals, and for such other processes as shall be reasonably necessary for efficient performance of its duties, or as may be required or permitted by law, provided that said rules and regulations may not be inconsistent with this title. Said rules shall be discussed in at least one public hearing after notice and advertised in the Mvskoke Nation News prior to adoption by the Citizenship Board. No, and then filing requirements for regulations. No rule or regulation of a Citizenship Board shall be of any force or effect until and unless a certified copy of said rule or regulation bearing the signature of the Citizenship Board shall have been published in the Mvskoke Nation News, filed for record in the office of the National Council Secretary, and filed for record in the office of the Clerk of the Mvskoke Nation's Courts. Okay. So that's where we are. Now this was the Citizenship Board's filing, and they're saying these are the things that we've got to do before we can give them citizenship. Let's go back to the process, or the ROA for this. So what just happened is on November 13th, the Supreme Court issues its order concerning this renewed motion for contempt. So let's take a look at what the Supreme Court ordered. So, order taking respondents, so on and so forth. I'm going to read through this because it also kind of recaps everything. This matter comes before the court pursuant to respondents' October 14th, 2025, renewed motion for contempt and for court enforcement of order and judgment and for order to show cause. The respondents advise the court that they have yet to receive notification from the appellant that their applications for citizenship with the Mvskoke Creek Nation have been approved. Further, the respondents argue a reasonable amount of time to establish procedures in line with the court's order and issue respondents' citizenship cards has passed. The appellant states that it has not willfully disobeyed the court's order and opinion, and that the appellant has not yet had the ability to comply with the order. The court takes the respondent's renewed motion for contempt under consideration and hereby directs the appellant to file a monthly status report with the court. The first report shall be due on or before close of business on Friday, December 5th, 2025. It is so ordered that the appellant's first status report shall provide the following information. With respect to appellant's October 27th response, provide the court with a summary explanation of each necessary amendment to policy and procedures that has been submitted by an MCN department in response to Principal Chief's August 28, 2025 executive order. Further, with respect to each proposed amendment submitted by any MCN department, Advise if the appellant intends to pursue that specific amendment. What actions have been taken by the department, the appellant, the National Council, and or the nation to date on that specific amendment. An estimated time until completion of that specific amendment. With respect to appellant's October 27th, I'm going to skip over this part because it's the same. A summary explanation of each proposed code amendment submitted by the Attorney General's office, and a summary explanation of each proposed amendment to the Citizenship Board's policy and procedures. What specific actions have been taken by the appellant, the National Council, and or the nation to date, as well as an estimated time until completion for each proposed code, policy, procedure amendment. All actions taken to date by the Citizenship Board to promulgate administrative rules facilitating the court's July 23, 2025 order and opinion. Have any proposed administrative rules been published in the Mvskoke Nation News to date? No. I can answer that for the court, no. If so, when? Have any proposed administrative rules been filed with the National Council Secretary? If so, when? Have any proposed administrative rules been filed with the court clerk? If so, when? Provide a summary, explanation of all anticipated questions of national significance to be answered by the elected officials of the nation. What specific actions have been taken on each question to date, and an estimated time until completion on each question. Provide a summary explanation of all additional questions that must be addressed, other than those mentioned above, before the Citizenship Board may issue citizenship documents pursuant to court's order. What, if any, steps have been taken to resolve those questions to date, and an estimated time until completion on each question. Provide a summary explanation detailing what the appellant asserts is a reasonable time frame for completion of all necessary steps prior to issuing citizenship documentation. And then I'm going to read this section here because this is underlined by the court. To be clear, the court anticipates this initial status report to cover all areas in which the appellant believes amendments to the nation's code, internal policies and procedures, or any other area are required. Failure to provide complete information in this status report or, in the future, to claim that additional areas must be addressed without good cause shown for the failure to include those items in this status report will be taken into consideration, both with respect to future status report requirements and with respect to this court's consideration of the respondent's renewed motion for contempt. Okay, so that was a lot of reading, but basically what it comes down to is, chiefs or the Citizenship Board was saying, hey, we got to do all these steps and we're trying to do them and we're working on it, but we haven't had enough time to do them. And then, so months are going by. And now the Supreme Court is saying, hey, we're not going to hold you guys in contempt, but we do want you to tell us everything that you think needs to be done and where you are with it and how long it's going to take you to do it, And that report's supposed to get turned in on the 5th. And then, I'm assuming, and according to the court says here, a new set of monthly status report requirements. So the next due date following the filing of previous month's status report. So they're saying that once we have the first report in, we'll tell you when the next one's due because they want to see some progress. I'm going to go through these questions here real quick. What they were, constitutional amendments. Why did the court neglect to inquire about amending the Constitution? So the court, the court isn't actually making any statement of what needs to be done, right? The court isn't saying anything. The court is just saying the Citizenship Board and Chief Hill are saying that these certain things need to be done before they can issue the citizenship cards, right? And the court is saying, great, tell us what they are and when you think they're going to be done, right? So Chief Hill or the Citizenship Board would need to say, hey, the Constitution needs to be amended. And they would need to say, we're planning on bringing in this report, right? If they want to bring that up, they can say, the Constitution has to be amended. We're going to bring legislation next week to get that onto a ballot so citizens can vote and all of those types of things. T.Y. Pearl saying it seems conspicuously odd that the court specifically omitted addressing the changes to resolve the conflict with the document that serves as Supreme law. So T.Y. Pearl, I think you got a misunderstanding about the process, right? The court's not claiming anything needs to be changed, right? That's the citizenship board. The court's saying, give them citizenship. And then the citizenship board and chief's office is saying, hey, we can't. We got to do all this stuff. And the court's like, what stuff do you got to do? When do you plan on having this stuff done, right? So it's not the court saying that what's going to be in these reports, other than to say to all of the parties concerned on that side, you guys need to tell us specifically what you're doing and when it's going to be done. And we need to be updated whenever we say, but looks like monthly, we need to be updated monthly on the progress of whether these things are going to be done. So unknowns with this is I don't know if these status reports are going to be added to the Supreme Court's website. I hope that they will be. And then we as citizens could click them and see what's going on. But also you would expect to see things getting posted to the National Council's committees. You would expect to also see things getting posted to the Mvskoke Nation News about these changes, or these meetings about these changes. Because if you remember what we read said that not only do the changes need to be posted in the Mvskoke Nation News, also notice of the public meetings that will happen before those changes can be enacted or done are supposed to be in the news. So we would expect to see notification that there's going to be a meeting or something coming up. But T.Y. for both the executive and judicial branch avoiding constitutional conflicts with this court order, can executive or judicial fiats overrule our Constitution? Well, the problem with the Constitution in this, bringing up the Constitution in this particular aspect is the Supreme Court interprets the Constitution, and they've said that the by blood part of the Constitution is void ab initio. So you're ruling on, trying to go back to the Constitution and say this is, the Supreme Court said that there is language that's in the Constitution that's void ab initio. It can't exist. There is no blood, basically, if that makes sense to anybody. So to have the Constitution get inserted into the process at this stage, you'd have to overturn that by blood thing, or you would have to amend the Constitution to specifically, I don't know how you could do it. I mean, I'm sure there would probably be a way, but it would definitely consist of a constitutional amendment to get around the Supreme Court's order in this. So, with that being said, I think we're all there, and I'm just looking through the questions here. T.Y. Pearl asks, will they be disclosing prior notice the times and location of the Citizenship Board regular meetings? I don't know. I mean, that's basically what the Supreme Court is saying is, you guys are saying you're doing stuff, but we don't see you doing anything. Nobody sees you doing anything. Citizens don't see you doing anything. Citizenship Board, we don't know if they're going to, and it's ordering them to tell everybody, right, with these reports. Specifically the Supreme Court, they're saying tell us, but you would also expect that we would get to see this too, because this is part of the process. If we're going to have these major changes to code or amendments to policy and procedures, citizens should be involved and should have input on it. So, does the executive or judicial branch have administrative authority over the light horse? The judicial branch does not, but the executive branch, I believe that light horse is in the executive branch. Who orders the light horse to enforce a contempt order? Well, I see where you're going with this, T.Y. Pearl. You're saying if the Supreme Court holds Chief's Office or the Citizenship Board in contempt, what's going to happen? Is that enforceable? Is there going to be anything happen to anybody? I don't know. It's happened in the past. You can go back in Supreme Court cases. For instance, I believe that the Supreme Court held the National Council in contempt at one point long ago. And we want to try to avoid that as much as we can. That's kind of why I threw in the Thlopthlocco coverage earlier, because the Thlopthlocco don't have a district court of their own. They don't have their own tribal court to solve any of their internal political issues. Part of having governmental authority is having some type of tribal court, because you get into situations where multiple people are saying, no, I'm in charge of the tribe, right? And if you don't have a tribal court or a place that everybody agrees on, we're going to follow what the rulings of this court says, then you don't have any government, is basically what it comes down to. You've got a bunch of people saying they're in charge of something, but you have to go to the state, you have to go to Mvskoke District, or you have to go to the Oklahoma Supreme Court or the United States Supreme Court to say who's in charge of your tribe, and that is probably not sovereignty. I don't think it looks like that, but that's my opinion. How can we get the BIA back in the citizenship office? Well, the BIA is involved in the citizenship office already, because tribes that have the ability to issue CDIB cards, right, they have an agreement with the BIA to do all of that stuff, right, to do the citizenship cards specifically. And if you guys caught the piece I did about citizenship card or CDIBs, I did a video on CDIBs, and also we did a thing on the web and in the paper about CDIBs, I believe it ran, which explains the problems with CDIBs. So that the CDIB is also probably not going to be a good way to solve this decision either. The tribal towns surrender their sovereignty and filed to resolve their conflict in state court. Well, T.Y. Prohl, you're saying the tribal towns surrendered their sovereignty and filed to resolve their conflict in state court, but the problem is there's a dispute over who's running the tribal town. So how does the court know that that the person who said they're waiving sovereign immunity has the ability to waive sovereign immunity? If you got one guy saying, I waive sovereign immunity, you got two other guys saying they're Miko and they don't waive sovereign immunity, did it get waived? That's the problem. And now we've seen, too, in that particular instance, that the BIA has changed their tribal directory to say they don't know who's running the show, which is a big deal. Okay. Anyway, so all of the links are on there, guys. Thanks so much for joining me today. We're at 4:41, and it's almost time to get out of here. I did want to let you guys know that I'm going on vacation next week, but I will be back at the start of December. And we will definitely, if the Supreme Court posts any reports in the Freedmen case to their website, as soon as I can get that, we will do a live stream on it and go through and see what's happening. And also, we'll be keeping an eye on committees and stuff. And if you guys ever go to the National Council's website, they post the agendas for their committees and stuff. You can scan through those and see if there's anything changing the process for citizenship or anything like that. And on these other cases, we'll be following along. The Strobel case at the United States Supreme Court, I didn't mention that, but the Strobel tax case has filed for certiorari at the United States Supreme Court. That certiorari has not been granted yet, but there have been some filings in there. But the Supreme Court, United States Supreme Court, has not said they're going to hear that case yet. So just to give you an update there, we're monitoring that, and as soon as there's a development, we'll let you guys know. And with that being said, Mado, Hadum, Chihichat, Lees.